Please confirm me if my slide is visible.
Yes, ma'am, it is visible.
Thank you so much for having me here. Good evening, everyone. Today we are going to discuss online defamation and legal redress, the laws majorly concerning social media slanders, cyberbullying, and the remedies that we have currently. So, this is one of the most practically relevant areas of law today in the digital age. Um, so, the moment I begin with the session, let me very briefly tell you that whatever the questions or the doubts are, I'll be taking all those questions at the end of the session. So, let us begin. All right. So, unlike any traditional criminal law topic that often remains theoretical, online defamation is something that you encounter every day on social media platforms, be it on Instagram, be it on Twitter, WhatsApp groups, YouTube comments, or even in Google reviews. So, let me begin by saying this very clearly that reputation is legally protected interest, and our courts have repeatedly held that right to reputation is an intrinsic part of Article 21, that is, right to life and personal liberty. So, when we talk about defamation, we are not merely talking about hurt feelings, we are talking about the constitutional injury that is causing to the individuals, the citizens who are getting harmed because of such online defamations. So, in the digital area, defamation has actually changed its character. So, earlier, defamatory statements were limited to newspapers, pamphlets, or spoken words, but today, a single post on any of the social media platform can travel across jurisdictions, be stored forever, and be algorithmically amplified. That is why online defamation is not simply old defamation in a new platform or on a new platform, but it is qualitatively different legal problem at in the current scenario at present. So this is the lecture objective that I have mentioned in my PPT. So, by the end of this lecture, I believe you would be able to understand what defamation means in law, how online defamation is treated differently, what are the statutes that are applicable today, what are the legislations that are applicable today in any kind of injury, and how victims should actually proceed in real life, and what new challenges like AI or any anonymity mean for the future of defamation laws. So, moving on to the foundational concept of defamation, under section 356 of BNS, that is Bharatiya Nyaya Sanhita of 2023, that is the latest amended law, defamation means making or publishing any imputation concerning any person with the intention to harm, or knowing or having reason to believe that such imputation will harm the reputation of that person. So now let us pause here and understand the structure of the entire definition. So the law is not only concerned with the intentional harm, but it is also concerned equally with the knowledge or reasonable belief of causing harm to the other person. So this means that even if you later claim that I didn't mean to harm, the court will definitely ask you, like, were you aware that it could possibly cause harm to the reputation of the person? Whether you had the intent or not, the harm will have the impact and you would have to suffer the consequences related to it. So, earlier we were taught the distinction between libel and slander. So, under defamation, libel was the written defamation, and slander was the spoken defamation. But in current scenario, in the digital world today, this distinction has largely lost its relevance. The reason being that courts treat online defamation also as libel, because digital content is something that is permanent, that is going to be reproducible, and that is going to be searchable easily. So whatever we put on the online platforms, even for once, is going to exist for numerous years. It is something that is not going to be removed or deleted. It is going to be stored, getting stored somewhere on the server, somewhere on the platform, that you would not be able to remove it entirely. So even something that appears temporary, for instance, like stories that we put or on Instagram or on WhatsApp status, or the disappearing messages setting that we have got today in WhatsApp, all these are going to be treated as evidence in future if something, if some sort of mishap happens. So these, all these stories, all these disappearing messages thing, these can be screenshotted, these can be forwarded, these can be archived, and these can be produced as evidence in the court of law. So, for our understanding, everything that is online is permanent. This is a simple sentence that we need to fix in our minds. Everything that is online is permanent in its nature. That is why the law takes online speeches far more seriously than any casual spoken conversation on out of the platform offline. So when we talk about why online defamation is more dangerous than offline defamation, first there is an issue of permanence that I just spoke about. Once something is uh, posted online, it does not really disappears. Even if the original post gets deleted, the copy remains on other devices, in archives, on search engine caches. So courts now routinely accept evidences from platforms like the Wayback Machine. So I'll explain what Wayback Machines are, just to show that what existed online at that particular time. Secondly, there is viral reach of the content that you are posting online. So earlier defamatory statements had a limited audience, but today defamatory reels, defamatory tweets, or posts can reach lakhs or even crores of people within a matter of few hours or few minutes. So the damage happens before even the victim becomes aware of it. The damage is already done. Third point that is very crucial is the context collapse. Now, online statement loses their original context. Sarcasms, exaggerations, or humor may not be understood the same way by all the audience. The law, however, applies the standard of a reasonable person, prudent person, not the subjective intention of the speaker. So, when courts assess online defamation, they focus less on what the speaker meant and more on how the statement could have been perceived by the public. Now, moving forward, I've explained libel and slander and the difference between permanence and how viral reach can be done and what changes could be made. So, moving next to the essential elements, five essential elements of defamation, and understanding how is it distinct from cyberbullying. So now defamation to be legally established, there are five essential elements that needs to be present. So first is that imputation, as I have mentioned in the slide as well. First is the imputation. This means that a statement or an allegation or representation about a person. So this can be direct or indirect or explicit or implied in nature. Second is the defamatory nature. So imputation must have a defamatory nature. So, in other words, it must lower the reputation of the person whom that statement has been made to target, and such statement should make the people of this society to rethink about that person. So, this means clearly that there is an intent to damage or harm the reputation of that person in the eyes of people who are living in that particular society. Third is that there must be a publication of the defamatory imputation that has been made, or the defamatory statement that has been made. So, publication does not mean publishing in a newspaper. It simply means that the statement was communicated to at least one person other than the victim. There can be two people also, there can be n number of people. So other than the victim, that particular statement must have been communicated to at least one more person. So posting in WhatsApp group or tagging someone on an Instagram reel or post, it also satisfies the requirement that the defamation has been done. Fourth point that is very important is that the statement must be false. Truth is a defense when we talk about defamation. So, truth is also a defense only in a situation when it is coupled with public interest. If a statement was made in public interest for public benefit or for public good, at that point only the exemption can be granted. Otherwise, the statement made must be false. Fifth essential point is there must be harm to the reputation of the person. So, in case of libel, harm is often presumed by law. Now, let us clearly distinguish and understand what cyberbullying is, because at times we have seen that cyberbullying and online defamation are seen as overlapping concept, whereas these two are very different concepts. So, defamation focuses on reputation, which usually requires a false information or a false statement to be made. But cyberbullying focuses on harassment and psychological harm, and it must involve true statements that are repeated maliciously. So, cyberbullying primarily it is addressed under IT Act, whereas defamation is addressed under BNS, the provision that we just saw, section 356, the online defamation provision. So the point that we need to understand is that all defamation is not cyberbullying, and all cyberbullying is also not a defamation. So, if we move to the provisions, we can see that cyberbullying has been addressed under 66D, 67, and 67A of the IT Act. Now, moving on to the next slide, where we'll understand as to what all statutory frameworks are there when we talk about um, online defamation and cyberbullying. So here under section 356 of Bharatiya Nyaya Sanhita, defamation is a criminal offense, but it is bailable and it is non-cognizable. So this is very important. It means that the police cannot arrest without a warrant, and the courts have to exercise greater scrutiny. They have to do greater investigations in such kind of cases, because again it is bailable and it is non-cognizable in nature. Non-cognizable just means that without police warrant you cannot arrest the person. Now when we look about the penalty part of it, the punishment may extend to 2 years. that I've mentioned in the slide as well. It may extend to 2 years of imprisonment or fine that the court will impose. That will depend upon the gravity of the case, the situation, or both. The court can also give imprisonment as well as can also impose fine, or can also give community service to the person as a matter of penalty or punishment. Now, this reflects that these penalties that have been given are far away from the excessive criminalization that we can see. So now online defamation rarely exists alone. It often overlaps with the provisions of Information Technology Act of 2000. For instance, fake profiles and impersonation. Fake profile and impersonation, it means that you are uh, trying to present yourself on the social media platform or on any online platform as somebody else. You are trying to copy the identity and the characteristics of a very different person. So this have been addressed under section 66D. Second is obscene images or mocked images or sexually explicit content. These have been given space under section 67 and 67A. So any such kind of activity gets attracted. The section that are applied is 67 and 67A. Next essential provision is 79. So, platform liability, social media platform or be it any platform liability is governed by section 79, which provides safe harbor. Now, what is safe harbor? We'll see that as well. So, however, this safe harbor is conditional in nature, it is not absolute in nature. This is where IT rules 2021 becomes crucial. So we'll see a number of cases. We'll see majorly five landmark cases in which we will see as to which particular case uh, was the initiating factor for IT rules of 2021. So the platforms must remove the unlawful content within 36 hours of receiving a valid complaint. This has been expressly mentioned in the user guidelines or on the grievance portal of all the social media platforms or all the platforms. So they must appoint a grievance officer and act with due diligence, and if they fail to do so they lose their immunity, and then safe harbor does not apply. So in order to apply safe harbor, if a particular victim, we can, we are just calling it a victim, so if somebody is complaining on the social media platform in the given portal of the social media platform that a particular content has been is defamatory in nature, just say, be it that the content has been is mobbed or an obscene content, or somebody from the fake profile approached that particular person and did any kind of damage to the reputation of that person, so we'll use a blanket term, that is defamation, online defamation. So if a social media platform or any platform has been approached by the victim stating that uh, they are the victim of a particular situation, there is unlawful content present on that particular platform, so from that very moment of filing the complaint, bringing to the notice of that particular platform, it is the duty of that platform to remove the content within 36 hours. So if that social media platform follows this, they very well get the safe harbor um, liability, the safe harbor safeguard for themselves. But in case they fail to do so, they lose the immunity of this safe harbor. Additionally, I have mentioned about DPDP Act, that is Digital Personal Data Protection Act. So under this act actually intersects defamation whenever the personal information or the personal data of the any individual or the victim is misused. So victims can demand erasure of defamatory personal data even when criminal prosecution is slow going. So next, moving to the other point here in the IT rule 2021, we can see that rule number 3 that I have mentioned, it clearly mentions that if there is an individual who is a repeated violator of such activity and multiple complaints, or in fact more than one complaint had also been raised to that particular platform by the victims, then that the account of that particular violator or that handle of the violator calls for a suspension. So the platform can suspend the account of such violator if there is repeated violation of the space or the what to say, the privacy of another person who is really not willing to share any kind of information with you, but you are trying to defame that person on the basis of uh, the images, fake profiles, any sign, any video, whatever we can imagine that can cause damage to the reputation of the person. So, moving to the evidence and civil and criminal remedies. So, I have here mentioned just a few terms, but we will be discussing all these terms in detail as to what metadata is, and what do we understand by this screenshots with metadata, what is server log, what is archive.org and everything. So, let me just begin. With this particular slide. So, in online defamation cases, um evidence is actually everything. The first statement that I mentioned at the very beginning of my session was that everything that is online is permanent. This is the first takeaway that we need to understand. And the second thing is that in cases of online defamation, evidence is everything. So, a casual screenshot without metadata is a weak evidence. So, in order to prove in the court of law that the defamation has been done, the screenshot must be time stamped, it must have hash value, the server logs must be obtained through court's order, and there must be the affidavits from expert forensic team. So we'll understand all these terminologies in our upcoming slides. So moving to the remedies, courts increasingly prefer civil remedy over criminal prosecution. So civil remedies include general damages, which are presumed, special damages, which must be proven by the victim. Third is the aggravated damages, where actually the malice or the intent is shown. Fifth being the interim and permanent injunction that is imposed. And last one is the content takedown order that is given in combination with all the damages. So, content takedown order can be given along with the general damage. Content takedown order can be given with special damage also and aggravated damage also, because content takedown is something that is of prime importance. First of all, the defamatory content must be stopped, it must be taken down, so that furthermore damage is not done. So in terms of limitation, I'll take that up in my upcoming slide. So criminal remedies still exist, but courts are very cautious because of free speech concerns, because criminal defamation is no longer the first resort or the first response. Generally it is treated as the last resort. So first of all, it is tried by the court generally try that the content is taken down, and whatever damage has been done, obviously it will depend upon the gravity of the damage as well. So whatever damage has been done, it needs to stop first, and uh, be it special damage or general damage, it must be awarded to the victim so that the reputational harm could be limited. Now moving to the defense and professional immunity. Um, Till now, we have discussed how defamation is committed and what remedies are available. Just a second. What remedies are available? But law is never one sided. So, the next natural question is, when is a person not liable to defamation or not liable for defamation? The question that is asked is, when is a person not liable for defamation? So, this is exactly what this slide is actually dealing with. These are called the defenses to defamation and the professional immunities that are given to certain classes. First of all, truth as a defense will understand this. So, the first and the foremost important defense is truth. This particular phrase we have seen earlier as well in our slide. So, many students, many readers, they think that if something is true, it can never be defamatory in nature or it can never be a defamation. But that is not fully correct in Indian law. Under BNS, that is Bharatiya Nyaya Sanhita, truth is a defense only when it is published for public good. So this means that there is essentially two conditions that needs to be satisfied when we say that truth is a defense. The reason being that it has been used for public good or for public betterment. So first point is that the statement must be true and it must have been published uh, to serve public interest. First is that statement must be true. Second, being that it has been published in public interest. So, for instance, exposing corruption by a police official with evidence is protected, but revealing someone's private life, even if it is true, without public interest, can still amount to defamation. So, the point that we need to remember is that the burden of proving truth lies on the defendant, not on the complainant. If I repeat, the burden of proving truth lies on the defendant and not on the complainant. So, if you make any allegation online and later if you say that it is true, the court will ask you to prove it as to how that particular statement is true. What made you believe that the statement is true? Next essential point is privilege. So, privilege means certain statements are protected because of the place or purpose when they are made. So, there are three important types that we should remember. First is the parliamentary privilege. So, the statements that are made by MPs or MLAs inside the legislature are protected, even if they are harsh or damaging. Second, judicial privileges. Anything said by judges, lawyers, or witnesses during court proceedings are protected. This is necessary so that people can speak freely without fear of being trapped in the defamation related cases. So judicial privilege is something where judges, judicial officers, lawyers, or witnesses, whatever they say in the courtroom, is protected. Third point is the legal privilege. The advice given by lawyers to their client in good faith is also protected. Though, so the idea is very simple. Some forums require complete freedom of speech for justice to function. So that is the reason these immunities have been granted to them. Next point is fair comment. So when we talk about fair comment, it is it simply means that it is an opinion and it is not a fact. So if you express an opinion on a matter of public interest, sorry, so if you express any opinion on a matter of public interest, such as governmental policies or public performance or public figure, that opinion is protected as long as it is honest and there was no intent to damage the reputation of the person involved. So, for instance, saying that I think this movie promotes harmful stereotype, this is an opinion. But if I say that the director committed fraud, this is a fact. ठीक है, this is a statement of fact. So courts allow criticisms, courts allow debates and disagreements as well, but what they actually do not allow is the false statements which are presented as facts. Facts and opinions, these are completely two different things. So opinions are protected, but facts, if they are wrong in nature or if there was malicious intent in presenting that, and that must be false, in that situation the protection is not granted. Next is professional immunity. So when we talk about professional immunity, here again there are different classes, wherein first that we'll understand are the journalists. So journalists are protected when they report matters of public interest. In these situations, the journalist, the statements made by journalists or the professional immunity is extended to the journalist. They are protected when they report matter of public interest. They are protected when they verify the facts and clearly they distinguish between opinion from the news. But the journalist loses, um yeah, but the journalist, they loses protection if they act recklessly, if they publish unverified allegations, or if they are majorly driven by uh, wrong intent or malicious intent or the intent to harm the intent to harm the person about whom the news is actually related to. So the freedom of press does not gives you the license to defame somebody, but it is something that this profession is actually made for public interest, for public good, to share the correct information with the public. So that is why a professional immunity are personal immunity, professional immunity is extended to such group. Next is lawyers. So lawyers enjoy absolute privilege for statements that are made in court that we have just seen. So this means that a lawyer cannot be sued for defamation for arguments that are made during the litigation period. So during litigation, you make n number of statements, and those statements cannot be treated as defamatory statements because those were the arguments that were presented in during the litigation period. However, outside the court, the lawyers are treated like any other individual, same as on social medias as well. Next are the public officials. So public officials can be fairly criticized for their actions, and courts allow criticism of government decisions, but personal attacks without factual basis are not protected. Now, next, moving on to the platforms that are social media companies. Here we'll see about section 79 that talks about conditional immunity that is given to them, which will come under the safe harbor provision. So, platforms like Facebook, Instagram, Twitter, etc., they enjoy conditional immunity under section 79. So conditional immunity, what do we mean by that? So they are protected only in given conditions. First condition being that they act as neutral intermediary, they are not biased in their nature, they are not trying to be on some or the other side, they have to be very neutral when it comes to uh, passing on the information, or when it comes to the user's privacy or their enjoyment of the rights on that particular platform. Second is that they must follow the IT rule 2021, that is very much applicable to them. And then The last point is that they must remove, or they do remove, unlawful content that is published on their website that has been brought to their notice. Initially, we have seen that if any of the victim approaches the social media platform stating about their unlawful content that has been published, so in these situations it is the responsibility of that social media platform to take down that content within 36 hours, as well as if that particular violator has been a repeated violator of the uh, code of conduct, or has such behavioral issues, then the account of that particular violator can also be suspended for like, it can be permanent, it can be temporary suspension as well. Next important point that we need to understand is the absence of malice. So whether it is truth, whether it is privilege, whether it is a fair comment or professional immunity that is granted, good faith is something that is of crucial importance. So if wrong intent, or intent to damage the reputation of the person has been proved, and it is the intentional damage that is done, most of the defenses collapse. So that is why courts repeatedly ask, was this said honestly? Was that statement necessary? Was that statement in public interest or not? So such kind of questions will come up, because if the statement was not necessary, if the statement was not made in uh, honest nature, and if it was not at all required for public interest, why such kind of statement was made just to hurt the person, or just to do reputational harm or damage to that person? So here what we need to understand, I'll brief down it into 4 points. First is that you are not punished for speaking the truth responsibly. If you are responsible enough, if you have well thought as to why you are making that particular statement, you are not going to attract any kind of penalty. Second, you are not punished for honest opinions. Third, you are not punished for doing your professional duties. Fourth, you are not punished for anything that is not actually intended, but you are punished only when the speech becomes reckless or intentional in nature. So, that is the balance defamation law tries to maintain between free speech and reputation. We do have the freedom of speech and expression, but it is also conditional under constitutional law. We need to understand that if we have the freedom to express ourselves, we need to be very much prudent as to what we are speaking, what um it is, how it is going to be perceived by the person about whom we are talking. So this is something that speech, freedom, and reputation, these three should be very much balanced when it comes to expressing it on any of the platform, be it online or offline. Next point that we will see are the case studies and victim action protocols. So let me now just walk you through what a victim should actually do. So, first, uh, preserve the evidence immediately. Second, report the content to the platform. There are options as to how we can report the content, unlawful content, onto the platform. So before using any platform, it is actually advisable and it is prudent to first visit the platform very carefully, as to just posting something for the views or likes, or just if you want to express yourself, that is fine, but you need to be protected. You need to understand as to how you are going to handle a situation if it really goes out of hand, if your information is treated in a wrongful way. Third is the cease and desist notice, that is the takedown of the content. The person is actually asked to take down the content that they have posted. Otherwise, um, the approach the victim can also approach the cyber crime cell. And fifth is filing a civil suit for damage and injunction. Now, in a business defamation case, courts often presume damages and grant interim relief very quickly. And in case of any anonymous harassment case, or in case of any cyberbullying case that I have mentioned here, in such situations, courts direct the platforms, the social media platforms, to disclose their user data through lawful orders. Because if the victim is just asking the platform to disclose as to who that particular user was, who made those comments and everything, then that particular platform might not actually share that data, because for them the data of each and every user of that particular platform needs to be protected. They have to protect the data of their users, so they will not be sharing that. So for that you need court order, so that it is now the duty of the social media platform to share that information with you. So now this slide is one of the very most important slide, because this is where we actually understood how theory and practical situations in life will work. So till now what we have discussed is what online defamation is, how it has been defined under BNS, and how platforms regulate, what efforts do platforms take once they are approached by the victims. But the real question is, what does a victim actually do, and what does the court actually look for? That brings us to the remedial part, the evidence part that we will discuss in detail, that I had mentioned in the previous slide. So when we talk about evidence, we are talking about digital evidence. So here most of the people think that a normal screenshot will do, but legally speaking it is not the scenario. So a screenshot without context uh, is just an image, so it does not prove as to when that content was published, how that content was published, by whom it was published, and to whom it was intended to. So courts today expect digitally reliable evidence and not just evidence. So this includes the screenshots with metadata, which means that that particular screenshot must carry date, time, the device information, and sometimes even the IP sources. This is important because online content can be edited, it can be deleted, and can be manipulated. But the screenshots with metadata is something that gives that is treated as digitally reliable evidence by the court of law. So, in serious cases, courts may direct the platforms to share server logs. Now, what are server logs? Server logs includes the IP addresses and the timestamps. Um, but that I just mentioned, that the platform will not directly share their IP addresses or timestamps with you until and unless you have got court order with you. So court order is the first thing that you need to take in order to get these server logs and all, because these server logs do have some um, not some, they have got a lot of informations about their individual users. So because of privacy concerns, the platforms don't just casually share that data with you. So to get that data you need to have court order with you. Next is that archived content, so especially from platforms like Wayback Machines. So if a defamatory content is deleted after publication, if a defamatory content is deleted after publication, archive records are it can still show that the content existed at that particular point of time. That is why it is called archive record. So courts in India have started accepting these kind of evidences. I'll When I'll discuss the cases, I'll tell you as to in which case this was established. So finally, in high value or contested cases, lawyers and the courts, they rely on digital forensic experts. So an expert affidavit certifying the authenticity of digital evidence, it significantly strengthens your case. And without expert verification of that particular evidence, the defense can easily argue that the content is fabricated, because I just mentioned that the content that has been generated online, it can be modified, it can be deleted, it can be tampered with very easily. So the point that we need to remember, the principle that we need to remember is that in online defamation, preservation of evidence is the most urgent thing that the victim needs to do. Later you can file the case, but until and unless you have the evidence with you, you won't be able to establish that in the court of law, because they won't agree with the kind of screenshot or the kind of evidence, or if you have not at all gathered any evidence. The first thing is that you have to gather evidence, you have to preserve your evidences. Next, moving to the civil remedies, which courts increasingly prefer in cases of defamation cases. So, civil defamation is not about sending someone to jail. It is more about compensation. It is more about correction and restraint. That such kind of activity is not repeated. So earlier, what I was discussing about damages, so I discussed general damage. So general damage means that the victim does not have to prove actual loss, or the harm to the reputation is just assumed in case of online cases. Second that I discussed was special damage. Special damage, example, loss of business contracts, loss of employment, or measurable financial harm can be treated as special damage. The aggravated damage, these are awarded when the defendant acted maliciously, like if the defendant refused to take down content even after being notified, or they deliberately amplified the false allegation that was made. So, the most powerful civil remedy in online defamation is the injunction. So, the courts grant interim injunction, they grant permanent injunction, or they give the content takedown orders. So injunction matters more than damages, because reputational damage spreads faster uh, in the online space. Now moving to the criminal remedies. Initially I have mentioned that under 356 defamation is bailable and it is non-cognizable in nature. So here the criminal remedy that we have is that there is imprisonment that is extended up to 2 years, there is fine, or there is both. But there has been a judicial trend where courts generally avoid moving to the criminal remedy. They generally prefer giving civil remedies to the uh, victims. So here, these are the current legal positions, and I have explained here as to in case of WhatsApp group messages, will publication of defamatory content becomes uh, it is established, and for this I'll be referring to the cases in the next slide. So moving to the landmark judgments that we have got here. First is the SMC pneumatics case. So in this particular case, the online defamation was actually recognized. So this is a case of 2001, and this was the case where for the first time online defamation was recognized. Here, it was established that emails and online messages can harm the business reputation, can damage the business reputation, and the court can further stop the publication immediately by granting injunction to that particular company. Next essential case is Swami Ramdev's case. Here it was established that online defamation is as serious as newspaper defamation, and the platform must act globally, because whatever content has been posted online is not viewed only in India, or it is not shared only in India, but it is something that has a very global reach. Next landmark case is Shreya Singh's case. So in this particular case, it was established, and it has been a landmark case. The reason being that Section 66A was struck down as being unconstitutional, and the court very clearly stated that defamation laws still applies to the online situations as well, and it protected free speech online. Next important case is MySpace Incorporation versus Super Cassettes. In this particular case, the major question that arose was about whether online platforms are liable for illegal content posted by the users. So here, the court held that the platform does not automatically becomes liable, but once they have received the actual knowledge about such postings, they must act. They must take efforts to remove that content and to take action against that violator. So this particular case actually laid the foundation of IT rules 2021 that I was discussing earlier. This is that landmark judgment. And the main takeaway from this particular case is that platforms must remove the defamatory content as soon as it comes to their notice, be it through the victim or on their own. And next important case is Santosh versus State. So in this particular case, what happened was defamatory statements were posted on WhatsApp group, and in this particular case, it was established that WhatsApp messages are not private in law. They are not treated as private in law. Group communication is also treated as publication itself. So WhatsApp defamation is legally actionable, and accordingly penalties will be imposed. Now coming to the emerging challenges, that is anonymity and the jurisdiction. So in cases of offline defamation, you usually know who made the statement, but in case of online scenarios, many people hide behind. So they make fake profiles, they approach you through proxy servers, or they make anonymous accounts. So this means that the person posting the defamatory content may not be easily traceable. You'll not know. They'll use fake username. There'll be no photograph, or photograph would also be impersonating in nature. They won't use real name as well. So you cannot force the social media platform to reveal the identity of their users on your own. You will need court's order to get this done. Next essential point is related to jurisdiction. So jurisdiction is something which means that which court has the authority to hear your case. This is the simple meaning of jurisdiction, as to in which territory that case is falling and which court has the jurisdiction to hear that case. So, in traditional defamation, this is very easy. The newspaper was published in one place, so the court has the jurisdiction of that particular place. But when we talk about online defamation, there will be a situation when the content may be uploaded in one place, viewed at another place, and the harm is felt maybe somewhere else. The damage has been done somewhere else. So in this scenario, the question becomes very essential as to which place will really matter when it comes to jurisdiction. So courts usually consider three factors. First is where the harm occurred. Next, where the content was uploaded. Third, where the content was uploaded is the second point. The third being that uh, publication place rule will follow. That is the choice of law, which means that the law of the place where the content was made available to the public for viewing. So Indian courts have increasingly accepted that if defamatory content is accessible in India and the harm of reputation is done in India, the Indian courts can assume jurisdiction. But in case where the infringer or the violator is abroad, it becomes very difficult to identify, and it becomes very difficult to settle down as to where that particular case can be filed. So do not think that the foreign platforms are beyond Indian laws. If harm happens here, courts here can intervene. So let me give you a very simple example. A defamatory post is uploaded from USA on a social media platform, obviously that is global in nature, about an Indian citizen, and it is read and shared in India. So in such case, Indian courts can claim jurisdiction because the harm to the reputation occurred in India. So that is how online defamation expands the traditional understanding of territory or jurisdiction. Um, Moving to the preservation and discovery of digital evidences. Initially as well, we have discussed that the screenshots must be time stamped. There must be metadata available along with the information as to the device information, the location details, the file properties, the hash value, and everything. Server log, we just saw that it is a digital record that is generally maintained by the social media platforms. These records show the IP address, the login times, the device details, and the location related to the information as to where that particular account or that particular handle was uh, first logged in. So, these logs are extremely important in online defamation cases involving fake accounts, anonymous accounts. Now, here I have mentioned about Wayback Machines, and at the very beginning of the lecture session only, I mentioned that I'll be explaining this as well. So, archive.org is a digital library. It is a digital library, and one of its tool is known as the Wayback Machine. So Wayback Machine automatically takes snapshots of the web pages at different points in time. So it shows how a website or web page looked on a particular date in the past. Why is this important in online defamation? Because very often defamatory content is published, it causes harm, and then it is deleted or edited. So later the accused may say that this content never existed or I never posted this. So in such cases, the Wayback Machine actually comes into play. Now, next, when we talk about chain of custody, it simply means that it is a clear record showing who collected the digital evidence and how was it stored and who had access to it. So digital evidence can be easily tampered with. Therefore, the courts insist on the fact that evidence collection is documented, files are stored securely, and no unauthorized person uh, has the access and has altered the data. So, in serious online defamation cases, courts expect you to get the digital forensic certifications to be to actually prove the fact that the evidence is intact and it is trustworthy and it has not been tampered with. Last is the expert verification. This is the digital forensic expert affidavit which we are right now talking about. It actually it is granted uh, to prove the authenticity of the digital evidence or the content, that the timestamps are also correct and the metadata is also intact and the evidence has not been manipulated with. So to understand the entire slide in a very brief manner, we have to take the screenshots very carefully. We have to preserve the metadata. We have to use court orders to approach the platforms. We have to archive web pages. Um we have to maintain proper chain of custody, and expert verification actually strengthens your case. It is in your favor. Next, I'll take just 5 minutes. Next is actually explaining the practical steps um, That is the victim action protocol as to how one needs to proceed with the thing. First is immediate evidence preservation, that initially also we have seen. Second is the platform report. The platform grievance tool must be used by the victim. Third is the cease and desist order, or the cease and desist notice. It needs to be sent through a lawyer to the offender or the platform, demanding the takedown, demanding the retraction of the information, demanding apology, demanding the removal of the content, or demanding the compensation or damage that it has caused. Next is the police complaint. So police complaint is uh, something wherein you file a complaint to the cyber crime cell. And the provisions that are attracted is, we have already discussed, section 356 of BNS, section 66D, 67A. Now it will depend what kind of infringement has been done. So the complaint that you are filing with the cyber cell, it must include the digital evidence that you have gathered. Next is the civil suit. So civil suit is filed in district court, and it is actually sought for monetary damages, interim and permanent injunctions, and for content takedown order from the court. And the last one is the arbitration, that is ADR. Some platforms offer alternate dispute mechanism as well, which is faster and which is less expensive compared to the general litigation that happens in the court. So the major takeaways that we have here is that we must use multifaceted protection. uh, the accountability of the platform is there, but at your end also you have to be very much careful. Timely action is very essential. By timely action, I mean is evidence preservation, and that the platforms must be approached as soon as you come across about any kind of such infringement of your rights in the digital space. And the emerging threats that we have right now is the deepfake, AI related things, synthetic media, and all. So these are the emerging trends. So with the technological advancements, these kind of threats will come on, keep on emerging. We do have certain laws and statutory protection related to it, but we need a more strong law when it comes to online defamation and other defamations that will be because of these deepfakes and synthetic media. And the remedies that we have studied is the civil damage, the injunction, criminal prosecution, and the platform redressal portal that is available. So, in concluding the entire presentation over here, finally, we must acknowledge that the emerging challenges related to deepfake and synthetic media, AI generated speeches, encrypted platforms, or jurisdictional complexity, these will be a challenge in coming future as well. And we need to address these very carefully. Defamation law is evolving, but enforcement is still lagging behind because of the rapid technological advancements. The future of defamation law will depend not only on the statutes but also on the accountability of the platforms and the digital literacy. That is why we all need to be very much aware as to how these platforms function. And in case of any infringement or damage, what should be done by us as victims? So, online defamation law today is about speed, evidence, balance, and responsibility. So, as lawyers, as prudent individuals, it is our role to be more aware about digital laws, more aware about these platforms as to how we can tackle any situation that comes our way. Thank you so much for attending this. And if there are any questions, please let me know. In case you have any question in future as well, you can just write it down on the email ID that I have mentioned in the slide. And I will also request the host that I'll be sharing these slides with her. So in case any of you want these slides, you can approach her uh, so that she can share these with you as well. Thank you so much.
Thank you so much, ma'am, for such an insightful and informative session. The way you explained online defamation legal remedies was truly valuable for all of us. We will move to the question answer session. Participants are welcome to ask their questions related to today's topic.
Deepika, I can see two questions in the chat box.
Yes,
If we
ma'am.
can start with that.
Yeah, sure. I will read the question. It's from Mr. Naveen. What are the biggest challenges in proving online defamation in court?
Thank you so much for your question, Naveen. But I think the question you have posted this question before, even before we started with the evidence part. So the biggest challenge in proving online defamation in the court of law is the evidence part only, because most of the victims, they are not completely aware as to how they need to, gather evidence against the defamation that has been caused to them or that is being caused to them. So in the slides also I have mentioned about getting the screenshots with metadata, all the informations and everything. So the challenge is that once you reach the court and if you're unaware as to how you should have actually gathered the evidence, it becomes the major challenge, because there is the victim is present in the court, but the evidence that you are presenting, if at all, it falls very weak. It becomes very weak in its nature. So it becomes very difficult for the court also to understand whether the information or whether the evidence that you are actually presenting in the court is uh, the original one, it is authentic, it is not tampered one. So for these points only, we need to have the expert affidavits, forensic affidavits. We need the certifications that the evidence is intact and it has not been tampered with. So the biggest challenge, according to me, is the evidence gathering and preservation part.
Okay, I will read the next question. It's from Mr. Pavan. How can students avoid spreading defamatory content unknowingly?
How can students avoid spreading defamatory content unknowingly? So, Pavan, thank you so much for your question. So, the first thing that we need to understand is what is the level of that particular student. Right now, accessibility to mobile phones and accessibility to any social media platform is not something that is related to somebody who is above 18 years of age. So right now, even kids of 12 years, 13 years, they are also using mobile phones. They have got very easy access to the mobile phones. So in this situation, there is the parental control that we need. But nowadays, like you have seen in IPC as well, that is Indian Penal Code, or in BNS as well, that everybody who is prudent enough to understand the repercussions of the act that they are making, they attract penalties. So here again, if a student is spreading any information, it is actually advisable to first cross check that information, verify that information that you are actually sharing. If still there is any sort of confusion, you must approach your parents or siblings, whosoever is available in your vicinity, to understand that if I want to share any content, is this the right content? Because the moment you get the second thought whether this is right or not, that means it is wrong. So it is advisable to take help of your seniors, of your parents, to understand as to what content you are actually sharing.
Okay, ma'am. I saw that Manohar Anandan sir raised a hand. If you want to ask any questions, sir, you can ask.
Good evening, ma'am.
Hello, sir. Good evening.
Am I audible?
Yes, sir, you are.
See, I just wanted to know how to safeguard us from cyber fraud.
So, cyber fraud is actually multifaceted. There are many phases of cyber fraud. So, if you are talking about financial frauds or financial deceits,
Yes.
specifically, are you talking about it?
Yeah.
Okay. So, sir, the very first information is that
You come to know only after you get into the trap. That's the problem.
that is true, sir. That is right. But whatever awareness we can gather initially itself, that is something that we can use as a preventive or a precautionary measure. So, the very first thing is that we must not share our personal data with anybody. So, in fact, in our Digital Personal Data Protection Act as well, personal information has been very clearly mentioned. So, personal information means your name, your address, your mobile number, it can be your age as well, it can be your gender as well. So any information that is not at all required to be shared with anybody, do not share that. Whatever transactions you are making online, you would have to double check that you are using the correct website. Do not just blindly trust the telephone calls or the mobile calls that you are getting. Do not fall into the trap of the offers. So in case if you are getting any information, like mostly we get call from for KYC validation, that you need to share your KYC documents. in
You're
such
right.
situations in such situations, you can directly walk down to your branch, that I got such kind of call. Is there any such requirement? Because generally, what we do is we generally give our accounts, personal account, or be it our company account, to only those banks who are there in our vicinity areas. So in those situations, we must go there. Generally, you won't receive call from mobile numbers if it is actually authentic one. So first cross check with your bank, verify it with your bank by physically visiting there, rather than just believing on the phone call that you are getting, because there is nothing in the re-KYC also that will stop your transaction. That also happens if you are not transacting for nearly 2 years with the bank. In that situation, your account becomes dormant. So 2 years is a long duration. So in any kind of financial frauds, in such situations, I would advise. In fact, I personally follow that. In if I get any such call related to any financial transaction, I am aware as to on which platforms I'm transacting. Avoid unverified websites to do any kind of online transactions, to make any kind of payments. And we need to be very much aware that how to use the UPIs, how should we use it. And in any situation, if you are not at all comfortable doing that, we can deal in cash. But because nowadays most of the platforms, even offline also, we see, even if you go to market and everybody, most of the people are using QR code to
CPay.
make payments, UPIs.
CPay.
So we need to get aware as to how these transactions are done. We would have to learn that, because right now that particular is only going, we have, this is a digital era, and now going forward also such kind of transactions, such kind of engagements with the digital platform will increase. So we also need to learn, we need to relearn, then unlearn, and then we need to relearn as to how to survive in the current scenario.
Thank you. You have answered me right. It was a good session. I thank you very much.
Thank you, sir.
Thank you, sir. Ma'am, we have another message. It's from Mr. Vyomkesh Pandit. He's thanking you for the session. And the question is, many YouTube bloggers criticize industries like the dairy industry for animal cruelty and promote veganism. How do we know whether such content is free speech or online defamation, and what legal remedies are available if it is false?
Thank you, Vyomkesh, for your question. But first of all, To before I answer this, we need to understand that online defamation is something wherein you are targeting an individual or a company, right? So when we talk about industry is a very, broader term to target somebody into. So if you want to exercise your freedom of speech, and you also want to be on the safer side, try not to indulge into any such kind of activity, first of all. And the second thing, animal cruelty and dairy industry, these two are very different topics of what we are discussing right now. But online defamation can only happen if you are targeting a particular company or individual or group of individuals. Industry is a very broader term. But if somebody is trying to, make false statements or defame a particular industry, it becomes a bit difficult, because who would be a victim, and how would you actually file a case? Against whom you would file a case? So had it been a particular company, it would have been easier for the company to file a case to become a victim as to what defamatory statements have been made. But it also matters that the person who is making defamatory statement, or who is defaming you online in the online space, what is his standing, how many followers does he have, how many people are going to take his statement seriously. This is also something that is very important to understand. Like, if I have one follower or two subscribers on YouTube platform, and if I am making any statement against anything, any industry, anybody, if that statement is really going to affect that person, in that situation only that person will actually try to, catch you as to how you made that statement about me or about my company. So the standing of both these parties will actually matter. Vyomkesh, is there anything else that I can answer for you?
No, ma'am, it's clear. Thank you, ma'am.
Okay, thank you. Is there any questions from others? So, okay. I sincerely thank Dr. Vaishali ma'am for her insightful session on online defamation and legal remedies. I would also like to thank all the participants for joining us today and making this webinar interactive and successful. We kindly request everyone to take a moment to fill out the feedback form that has been shared. Your feedback is very important to us and will help us improve our future sessions. Thank you all for your time. Stay connected with Avanzo Cyber Institute for more webinar sessions. Thank
Thank
you.
you, Deepika.
Thank you, ma'am.
Thank you so much, everybody.
Thank you, ma'am.